Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to Life with GDPR, a podcast where I work in conjunction with Jonathan Armstrong, partner at Cordery Compliance in London, and a well-known data privacy, data protection expert. Life with GDPR is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox and Jonathan Armstrong back for another episode. In this episode, we are going to take on Brexit, and we're going to ask you if you're prepared from the data protection compliance perspective, data privacy compliance perspective for Brexit. We're recording this episode in late September, so when it goes up, the countdown to Halloween will be on. And I can only say once again, I cannot think of a more appropriate holiday for Brexit to occur than October 31. So, Jonathan, with that somewhat long-winded introduction, welcome back.
Thanks very much, Tom.
So, Jonathan, I guess perhaps to start with, do you have a few thoughts on what companies might be thinking through, or what they might need to be thinking through to start to prepare for whatever type of Brexit occurs?
Yeah, I do. I mean, there is no doubt that this is a complex topic, so let's just say that from the start. And it's also a topic that is evolving on an hour-by-hour basis. So neither of those are a good thing. But there's a couple of situations we should look at. I think US corporations exporting data from the UK, and let's assume for all of these discussions, it's what's called a hard Brexit or no-deal Brexit. So there's no provisional arrangements entered into. So for US corporations, what should they do about data leaving the UK? What should they do about data being transferred within the EU? And let's look at things like DPO and DPR obligations at the end. So the data transfer piece first. We've recently had some guidance from the UK data protection regulator. And my colleague Andre Bywater summarized that on September 16th on our website. And effectively, the UK regulator is advising people to prepare for all scenarios, and that would include looking at a no-deal Brexit. Now, this guidance isn't especially new, and it's important to remember that guidance is guidance and law is law. So whilst the UK regulator can say that if people follow her guidance, she might not take enforcement action against them, it's not entirely up to her. We've seen in the Schrems cases, for example, how issues like data transfer come before the courts as well as before the regulators. And we're likely to see some litigation post Brexit, I think, regarding data transfer to the US, particularly because some of those people who've complained about US law enforcement, particularly, live in the UK and might take the opportunity to issue some form of proceedings. But despite all of that, the current anticipation is that in terms of UK-US data transfers, the UK would enter into some sort of deal that's somewhat similar to Privacy Shield. And that is the anticipation of the UK Information Commissioner. And she might be slightly lenient to any organisation that relies on a Privacy Shield registration whilst that scheme is being created. There's also
Can you remind us the basic requirements of Privacy Shield?
So for Privacy Shield, it's the scheme that replaced Safe Harbor after the Schrems decision. You basically check whether the person you're sending data to is registered under Privacy Shield. There's a list that the US authorities maintain. And if they have a current registration for Privacy Shield, you can essentially rely on that to legitimize the data transfer. You should still have a written agreement in place with them, which will say things like you will stay in Privacy Shield, you'll observe its provisions, etc. But it's an easier way sometimes of ensuring the adequacy of data transfer. So to step back a bit, to transfer data from the EU to the US, you have to make sure that there's a way of legitimizing that transfer. That could be consent, although that's unlikely to help in an employee-employer situation. It could be privacy shield, or it could be standard contractual clauses or model terms. Now, both privacy shield and standard contractual clauses are subject to challenge from the courts. The next step on that case is likely to be early December, when the Attorney General of the European Court issues an opinion on its legitimacy. But at the moment, those measures might plug the gap, certainly between through November and possibly beyond, depending on what the decision is in December. So, in summary, UK to US, there should not be too many issues, we're hoping, provided, of course, that you've got the right agreement in place, which will either be an agreement that will follow standard contractual clauses in most cases, or an agreement saying that the party you're sending data to, which could be your parent company, will observe privacy shield. The case that's slightly trickier, but according at least to the UK regulators, not super tricky, is a transfer of data from the EEA, that's the European Economic Area, to the UK, assuming that the UK doesn't remain in the EEA. Now, that might be particularly relevant for an organization that employs people and centralizes some of that activity in another EU country. So let's say, for example, that you're a US corporation, you have European operations are headquartered in Amsterdam, and you're exporting UK payroll data to Amsterdam to process across the EU. Then you'll need some sort of measures in place. And again, standard contractual clauses are likely to be the most convenient. And you'll need to make sure that you have standard contractual clauses in place prior to October 31st, assuming there's a no-deal Brexit. So that should be a relatively simple job and is a wise preparation. And the regulators said, and I quote, "It's crucial that organizations make sure they properly prepare for all scenarios. If your organization sends or receives personal information to countries that are out of the EU, then you'll need to take steps now to prepare." So in some respects, that's, again, a relatively easy fix. Put standard contractual clauses in place for the transfer of data from the UK to the EU. Now, there are two other scenarios: a transfer of information from the EU to the US and a transfer of information from the EU to the UK. I hope you're following all this, Tom and listeners. The first one of those, EU to the US, shouldn't be affected much at all, other than the fact that the UK won't be in the EU. So if you already have standard contractual clauses in place, they should still be valid. If you're relying on Privacy Shield, that should still be okay. The only difference is it won't include UK data, and you'll have to do something extra if you're also dealing with UK data. So one of the measures I've discussed already. The trickier bit is EU to the UK. UK becomes what's called a third country, so it has a similar status to the US. Some people think that the EU authorities will expedite an adequacy hearing into the UK, so they'll try and get the UK as a safe country for data protection, similar to the adequacy decision in favor of Canada. Some people think that the EU authorities will try and expedite that. We're not entirely sure that that will happen. My gut feel is that can't happen before October 31st. And There are all sorts of, so again, the answer to that is likely to be standard contractual clauses. So if you've an EU entity transferring data to the UK, then put a contract in place prior to 31st of October. So hopefully the data transfer position is manageable, and we at least have a short-term plan to deal with all of those four scenarios. There's a little bit more complexity in terms of lead supervisory authority, data protection officer, and data protection representative. And I can maybe explain each of those as well, if that would help, Tom.
You bet.
So as far as lead data protection authority is concerned, then many of you will remember that most organizations who do business in the EU will have a lead data protection authority. Even US corporations, they'll commonly have a lead DPA as the authority that has the most connection to their data processing. So, for example, in the case of Google and Facebook, we know that Ireland are the lead DPA. Now, there's obviously some complexity to who the DPA is, and there's some litigation over this in connection with Google's £50 million fine and in connection with some cases coming out of Belgium. But probably it is the case that if your lead DPA is currently the UK, you'll need to look at a different DPA in the EU remnant from November onwards. Now, again, you can normally determine your DPA by, we would normally go through a questionnaire with clients to work out who that is, depending on employees, where you process data, where decisions are taken, etc., etc. But it's probably a good idea to work out now who your lead DPA would be if the UK isn't in the EU, and maybe even to make overtures to that lead DPA to understand a little bit more about them and how they may regulate you once, if Brexit happens. If your lead regulator in the EU is currently the UK Information Commissioner's Office, then you've probably registered your DPO with the ICO. If the ICO fails to become an EU DPA, then you'll need to re-register your data protection officer with your new lead DPA. Now, in most cases, that's just a matter of filling in a form or writing a letter. But again, that's something that it would be wise to get ready to do on November the 1st, because some authorities are currently conducting audits into who the DPO is, and you'd want to approach them before they approach you. Again, some process behind that, but relatively easy to work through. The trickiest decision of the lot, I think, is the appointment of a data protection data protection representative. So for some organizations who do business or monitor the behavior of people in the EU, but are not based in the EU, they have to have a data protection representative. And again, for some, they'll have appointed a DPR that's based in the UK, and they may need to think about that DPR moving as well. That might be more difficult than moving the DPO for some technical reasons that would be too long to go into here. But bear in mind the fact that for some people, they'll need to be able to do that task as well on November 1st. So in the data piece alone, there's quite a lot of preparation that will be needed. People have only got about a month left to do that. My suggestion is it would be wise to start that preparation now. The chances of a no-deal Brexit seem better than even, regrettably. Whilst we can all have personal views on whether that's a nonsensical situation or not, I think that is the situation we're in, and organisations should prepare for a no-deal Brexit and put those plans in place.
Well, Jonathan, this has been a fascinating exploration of really exactly what you said, the things you need to think through to be prepared for Brexit with this ever complex and evolving target of whether there will be, I was going to say we, but it's actually you, have a no-deal Brexit or some other solution is found. So I look forward to seeing what transpires on an hour-by-hour basis up until Halloween.
Thank you, Tom.
Hello, everyone. This is Tom Fox. I'd like to thank you for listening to this episode of Life with GDPR. If you have any questions for Jonathan, you can reach him at jonathan.armstrong@coteries.com. You can reach me at tfox@tfoxlaw.com. I hope you will join Jonathan and I again where we take a look at another topical issue related to data privacy, data protection, and GDPR going forward. Life with GDPR is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks again for listening.